Florida estate lawyers and the attorney-client privilege. When does an attorney-client privilege arise to protect supposedly confidential communications? Hello, my name is John P.L.C. Today is May 18, 2016. I'm a trial lawyer with the P.L.C. law firm in downtown West Palm Beach, Florida. Our probate litigation law firm handles trials and disputes involving wills, trusts, estates, guardianships, and related commercial and business litigation. So if you're an estate planning attorney in Florida, sometimes you're contacted by a son or a daughter, a mom or a dad, and you may provide an estate plan for them or provide legal services for them in which an attorney-client relationship in Florida exists. Now, what happens if somebody else speaks to you as a Florida trust lawyer or a Florida probate lawyer, but they don't hire you? Are the communications that someone speaks to you as a Florida probate attorney about protected from dissemination to third parties, and are they privileged? Does the attorney-client relationship exist? Well, if you're wondering whether you have an attorney-client relationship with somebody, like whether you're a particular client who has contacted a Florida probate lawyer, or maybe you're a potential client or a prospective client who's contacted an estate litigation law firm regarding some Florida inheritance, you might be wondering if that communication is privileged or not, whether somebody can testify to what you spoke to that Florida probate lawyer about. Same thing if you're a Florida estate lawyer. If somebody called you up, spoke to you briefly, can you handle a case that's adverse to that person? Or can you disseminate that information, or is it protected by the attorney-client privilege? Well, here's the rules. Here are the rules for that in Florida. You can read the Valerie case, Valerie versus Florida Elections Commission. It's V-A-L-L-I-E-R-E, 989 Southern 2nd, 1242. This is a September 10th, 2008 case from Florida's 4th District Court of Appeal. Now, this is not a probate case. This is an attorney-client case. And what the 4th District Court of Appeal did is they explained what the test is for an attorney-client relationship and what courts should be considering when determining if certain communications with Florida lawyers are privileged or not, right? So I gave you the citation for this. Valerie is spelled V-A-L-L-I-E-R-E, September 10th, 2008. And what the 4th District Court of Appeal does, it's trying to help determine whether an attorney-client relationship existed. And it starts out by saying what the standard of law is. First of all, whether an attorney-client relationship exists in Florida is a question of fact. So that means a trial judge typically is going to determine whether a relationship existed. Now, the test for determining whether an attorney-client relationship exists is the following. First of all, you should know it's a subjective one. Whether somebody who is approaching an attorney believes they're seeking legal advice, and whether they believe that they're forming a relationship. And it can also be subjective on the part of the attorney as well. What does the attorney believe or think or feel? So it's a subjective one. It hinges upon the client's belief that he is consulting or she is consulting a lawyer in that capacity. And his or her manifested intention is to seek professional legal advice. That's the standard of law of review for determining whether an attorney-client relationship exists for the trial courts and at our appellate courts. It cites a couple of cases that you can read about if you want to learn more about this particular legal issue. But understand that although whether an attorney-client relationship exists or is believed to exist in the mind of the client, it's a subjective belief, right? It's a subjective belief, but it has to be a reasonable one. Courts won't uphold a belief that an attorney-client relationship, if an attorney-client relationship exists, if that belief is not a reasonable one. So what do courts look to determine whether a belief that an attorney-client relationship exists is a reasonable one? Put another way, what do courts in Florida look to try to determine whether a client believed he or she was seeking professional legal advice when speaking to an attorney? Well, first of all, you need to know what they were discussing and what they were talking about. Were you talking about legal matters, or were you talking about politics? Also, where did the communications take place? Was it at a law office, in a conference room, in a partner's office, or was it at a party or a social gathering? At the trial court, the judge needs competent substantial evidence to make the finding of fact that an attorney-client relationship existed or did not exist. The trial judge needs competent substantial evidence to determine whether a client or a prospective client had a subjective belief, a reasonable belief, that he or she was communicating with an attorney in Florida to get or to have rendered professional legal advice. That's the test. And finally, the important point that Florida probate and estate litigation law firms are going to want to know is that the competent substantial evidence that a trial judge relies on to make that finding of fact can be based on conflicting evidence. My name is John P.L.L.C. This concludes my remarks about Florida estate lawyers and the attorney-client privilege.